Right away, we're stepping into a courtroom moment that looks procedural on the surface. But trust me, these early details matter. Case numbers, dates, and motions like this often decide whether justice moves forward or gets delayed. Keep an eye on what's being corrected here.
Central. All right, let's go ahead and address 2025 CF 3651, Luz Marie or Marlene Cron.
Good morning again, Your Honor.
Morning.
St. Cron, place for right here. Please sworn. Please always swear affirm testimony shall be established.
All right, there was a motion for or grounds to believe that the client was not competent to proceed.
This right here is about competency to proceed, a huge legal checkpoint. If a defendant isn't mentally competent, the entire case hits pause. And notice the tension? A simple clerical error almost triggered a hearing before the doctor could even finish an evaluation. In court, timing is everything.
We addressed that 2 days ago at the pretrial. And then apparently my assistant put the wrong date in the order and set it for a status hearing today. It should be September 29th, not today. There's no way Dr. Duros can do a report in 2 days.
Thank you, Your Honor. We did address that in the email.
All right. So if we can just generate some court minutes for this case that indicate that the competency status hearing is September 29th, not August 29th. And that would be at 10 a.m.
And here's the pivot. We move from paperwork to consequences. What you're about to hear is the prosecution laying out why this wasn't self-defense, was an accident, and why the jury's verdict carries massive weight.
And Your Honor, I just want to put it on the record that she's scheduled to do inpatient treatment for about 4 months on beginning 9/5 at Aspire. I'm sorry, 9/8 at Aspire.
Okay.
And she's to speak with mental health court for screening on 9/5.
Okay. Well, then she's probably going to need to see Dr. Duros before then. Okay.
Your Honor, by returning a verdict of guilty for second-degree murder with a firearm in this case, the jury rejected that this was a case of stand your ground or self-defense. They also rejected that this was a manslaughter and found instead that the defendant acted with a depraved mind under the law. Now, the family, as you've heard today, would like to see a life sentence, and that's justified. This defendant took someone away that can never be brought back. A father to children, obviously a son, a boyfriend, a friend, a brother.
This is the emotional core of sentencing. The law talks about intent and depraved mind, but the courtroom is also grappling with irreversible loss. A life taken, a family shattered. Here's the question for you. When a jury rejects self-defense, how much mercy should still exist at sentencing?
And what sticks out to me in this case is in the video that you hear that the jury heard in this case, he had an opportunity not to do this. He was warned by Tara Walker, who just spoke to the court, don't do this, don't take your gun out. This wasn't a spontaneous thing that happened. This took time. He went and retrieved the gun, and then even in that moment before, if he'd have made a different decision to not pull the trigger, nobody would be here today. But he did make that decision. So I understand the statements by Mr. Doherty and by his family, but ultimately what he's taken away and what he chose to take away cannot be given back. And so the state believes that life in prison is appropriate. Thank you.
All right, both parties have reviewed the PSI.
Yes, Your Honor.
Any additions or corrections or objections to it?
No, Your Honor.
None from the state.
There was an amended one filed. It was a correction in regards to the minimum mandatory, I believe. That may have been a correction.
Right, that was the one that was filed on the 28th.
And Judge, if I can approach with the score sheet.
Have you seen the score sheet?
Yes,
It's been reviewed by your client.
You haven't seen it? No.
Now we're in the technical phase, score sheets, restitution, credits for time served. It may sound dry, but this is where the sentence gets locked mathematically. Once these numbers are confirmed, there's very little room to maneuver.
Let him take a look at it. What's the time? 83? All right, Mr. Doherty, you've had an opportunity to review the score sheet with your attorney.
Yes, sir.
All the information on the score sheet is accurate?
Yes, sir.
Any restitution?
No, Your Honor.
Any cost of investigation?
No, Your Honor.
And there it is, life in prison, with the door to freedom effectively closed. Appeals are possible, but they're uphill battles. Drop a comment below. Do you think the sentence fits the verdict, or should the law allow more flexibility once intent is established?
Mr. Doherty, you were, or Mr. Thompson, you were privately retained? All right. Court did sit through the entire trial in this case, is aware of what the facts were that came out during the course of the trial. I've considered the pre-sentence investigation, the score sheet in this matter. I've considered the sentencing memorandum that's been filed by the defense, and I've considered the presentation of the witnesses and the arguments of the attorneys here today. Given all of that, I'm going to impose the following sentence. I'm going to adjudicate you guilty of the offense, sentence you to life in the Florida Department of Corrections with a life minimum mandatory for possession, discharge, and death of the alleged victim in this case with a firearm. You have 83 days credit time served towards that sentence. I'll impose court costs, cost of prosecution fee. Those costs will be reduced to a final judgment. Any other questions or concerns? All right, sir, you have the right to appeal the judgment and sentence of the court. If you wish to do so, it has to be done in writing within the next 30 days. If you cannot afford to hire an attorney for the purpose of an appeal, one could be appointed for you. We'll be in recess.